Growing up, we were always taught there's 3 things you don't talk about. 1, politics, 2, religion, and 3, how much money you make. 2020 pretty much did away with that first prohibition. However, today we're going to talk about number 3 and whether employers can prevent employees from talking about their salaries at work. That's next on Employment Law After Hours.
All right, welcome back to Employment Law After Hours, your favorite weekly series navigating the issues keeping employers up at night. I'm Monica.
And I'm Brian.
And today we're going to be talking about the National Labor Relations Act and whether an employer can prevent their employees from talking about wages in the workplace. But first, turning it over to Brian.
We have to say that we're both Ohio attorneys. However, we're not yet your attorneys. Therefore, nothing we say today should be taken as legal advice. It is solely meant for educational and informational purposes only. As Monica stated, today we're going to discuss the National Labor Relations Act and whether employers can prohibit their employees from discussing wages and their salary in the workplace. To start you off with some background on the National Labor Relations Act, I'm going to turn it over to Monica.
All right, so the National Labor Relations Act is a federal law that's existed for over 80 years, and it essentially protects an employee's right to engage in concerted activity in the workplace.
Concerted activity is essentially the ability of an employee to discuss their work conditions, including their benefits and payment and other workplace policies with co-employees or other individuals within the workplace without fear of retaliation or punishment from their employer.
So what you're saying, Brian, is that the very thing that we've sort of been told our entire lives not to do is actually something that's really protected activity now.
Yeah, that's correct. So our entire lives we're told, hey, do not discuss your wages, do not discuss your salary, how much money you make, especially with those in the workplace. However, it's actually specifically against the law under the National Labor Relations Act for an employer to limit the ability of an employee to discuss, again, their wages and benefits, work conditions, and policies with their coworkers.
So it's actually pretty interesting because then that would implicate a few things if, an employee chooses to put something like that in their handbook or otherwise take an adverse action against their employee for doing so, right?
Yeah, absolutely. And one of the biggest places we see this really arise is when the National Labor Relations Board decides to review or audit an employer's handbook, which they reserve the right to do. And in that handbook, they find policies or other statements that otherwise prohibit or limit an employee's right to discuss those topics with their coworkers. If an employer were to otherwise limit the rights of an employee to engage in concerted activity, they could face fines and penalties from the National Labor Relations Board and otherwise face lawsuits from their employees. So it's definitely something that you're going to want to audit or have your attorney audit your handbook to ensure that there's no policies that could otherwise limit an employee's right to engage in that concerted activity.
Those are all good points, Brian. Do you have any suggestions as to what an employer could maybe do in order to protect themselves?
Sure, absolutely. And another question we often get asked is, well, how do we keep our employees from discussing their wages and benefits, legally? Again, there's not much you can do to limit that. However, if you create an atmosphere that encourages employees to come to HR and discuss their concerns about their benefits and wages, they'd be maybe more likely to discuss those concerns with, again, HR or managers rather than their fellow coworkers. Don't give them that opportunity to want to complain about your policies, wages, benefits with each other. Again, foster that community of trust and create that environment where they come to HR directly.
And just one more thing that employers should maybe be mindful of is engaging in market analysis as to what employees in their respective positions should be paying and sort of trying to keep up with those market norms so that this doesn't become an issue in the first place.
And along those lines, if an employer is engaging in those analysis and ensures that their employees are making, what the average is for their position, you're going to be able to avoid a situation where an employee is complaining, otherwise disgruntled about their pay, as long as they understand that, that is the average for our market, years of experience and position.
Right.
Well, that's all we have for you today on Employment Law After Hours. Don't forget to hit that subscribe button, click on that like button. If you feel so inclined, click on that bell so you're notified next time we upload a video. We'll see you next time.
We look forward to it.